Good morning, everyone. Welcome to our webinar for today on a day in court. What happens when your business goes to court? My name's Jodie Thomson. I'm a practice leader in the disputes team at LegalVision, and I'm presenting today with my colleague Simon Hillier, who's a lawyer at LegalVision. First, acknowledgement of country. LegalVision acknowledges and pays respect to the past, present and emerging traditional custodians and elders of this nation, in particular the Gadigal people of the Eora Nation, whose land LegalVision's headquarters is situated on, and the various lands on which those of you are joining us today. Just a couple of housekeeping matters before we begin. You will be emailed a copy of this recording afterwards, so don't worry about taking notes, or in case you miss something, you'll have a chance to catch up. If you have any questions along the way, submit them in the questions in the chat box, and we'll do our best to get through as many as we can at the end of the presentation. And we'd be really grateful if you could complete the survey after the webinar. So, talking today about what it actually looks like to go to court. It's a brief overview just to give you an idea of the timing and the processes and the different types of matters. We'll talk through the types of court and tribunal proceedings, what that process looks like with a bit of detail along the way, settlement and mediation options, how to get an out-of-court settlement, what it means to use a barrister, enforcing a judgment after you win a court hearing. Very important, the cost of going to court. And then we'll have a Q&A session at the end and finish with a bit of discussion about LegalVision's Pro membership.
Wonderful, thanks Jodie. So we'll jump right into it. The first question that comes to my mind when talking about what it looks like to go to court is what you're actually arguing about. There's a whole different range of claims one could make at court. But when we're talking about business disputes, when we're talking about commercial disputes, we've pulled out some examples that are perhaps the most common that we would see day to day. First on the list being a claim for money owed. This could be something as straightforward as an unpaid invoice, a debt recovery claim, or it could be something more complicated and contentious, such as arguments about another business causing you to suffer loss and damage and you wanting some kind of monetary compensation. So that's the first sort of claim you'd expect to see in commercial litigation.
You might also need to go to court or have somebody take you to court looking for specific performance orders. For example, it might be an order for a party to continue with a sale contract, or give an extension on a lease term, or do some work under a particular services contract. The court isn't limited to only making orders about money. That covers the second point. Orders regarding a lease, very common type of dispute that we're often in court for.
Oh yeah, orders regarding a lease, it's a good example of something that's a bit more subject matter specific, because there are specific remedies you can seek from a court in relation to a commercial lease. For example, if you feel you've been evicted from a premises unfairly or unlawfully, there's ways you can get a court to potentially reinstate entry to the premises. So there's lots of different remedies a court can provide depending on the circumstances.
If you are in a dispute about a company, might be a dispute between the directors and shareholders, then these end up in court under the Corporations Act, and it's a particular type of claim, and you might be asking the court to make orders in relation to those parties in a company, for example, ordering that the company buy out the shares of the other shareholders or even wind up the company.
Another type of claim we see quite frequently is what's known as an injunction, which would be something that's usually an urgent claim to get some kind of immediate order, and it might form one element of a bigger court case. And an example of that is you might seek an urgent injunction to freeze a party's assets during the course of a dispute, so that, for example, they don't get taken out of the country. So those 5 examples, that's just 5. We could probably talk for the entire half an hour about different types of proceedings, but this is just to give a flavour of the types of things that we see day to day.
So the court process can be quite long-winded. It's common for matters to go through court and take up to a year or two. People often think it's all over in a few weeks, but it's a really long process. So if you are thinking of having something resolved in court, you need to be aware that it doesn't move quickly and you don't have much control over it. We've set out here a bit of an overview of what that process looks like. This is just a skeleton example of the key points. In practice, there's often a lot of time and detail in and around these points, but just to give you an idea of what it looks like from beginning to end. The first step is if you're initiating the proceedings, it's preparing the claim, and that's actually setting out what your grievance is against the other party and asking the court for the orders that you want, whether it's money, setting out why the other party owes you money, if it's for specific performance orders, setting that out in a quite legal form. It's usually called a statement of claim or an originating process. It varies a little depending on the court. The next step, which is often a surprisingly frustrating and complex part of a legal proceedings, is that you need to serve those originating documents. Once they've been filed in the court, you've got a court stamp and a court number on the other side so that they have notice that they're being sued or that they're on the other end of a court claim. If it's a company, it's a question of just posting it to the company's registered address. But if you're suing an individual, then the court documents need to be personally served on those, and you need a process server, which is a expert person whose job it is to serve court documents. And it has to be done in a certain way so that the court is satisfied that they have received the claim. So you can't then carry on without them having notice of it.
And I think this is a really good point to emphasise, because we've had cases before that have been held up at the service stage simply because we can't locate the individual defendant. It's worth knowing as well, if you can't locate someone, you can actually ask the court to have substituted service. And we've served court documents before through channels like social media and email and text, which is quite interesting and modern, but it's not always the case that you can do that. And it certainly slows proceedings down if there's difficulties at the service stage.
The next step, well, once one party is served, they will usually have an opportunity to file their defence or their response, which is responding to whatever claim is made in your claim document. And then once that's filed, the court will usually list the matter for some sort of preliminary appearance. It's essentially a case management or an administrative hearing, so the court can check that everybody is aware of the proceedings and set out some sort of timetable for what's next. It might be that there are a number of these preliminary appearances before things actually really get going.
And some of them can be, as Jodie said, administrative in nature, working out a timetable. Other times there can be substantive issues that are heard at these cases, so they can be contentious. For example, one party might say, I want them to put money sort of into the court's bank account to guarantee that there's security to cover my costs if they lose. So you can have technical but substantive questions like that come up that form early arguments, and it means that a court case often involves, quite a drawn out sequence of appearances before, the hearing at the end or the trial that you might sort of expect when you think of court proceedings.
So usually at one of those early appearances, once any other issues are cleared up or dealt with, the court will set out a timetable for the things that need to be done before the hearing. The main thing that usually needs to be done is for the parties to put on their evidence. So the evidence can take different forms. It's usually in the form of an affidavit from the main witness or multiple witnesses. So for example, if you're the director of a company and you're making a claim against another director or another company that they owe you money, the director of the company would put on an affidavit to set out the facts behind what's gone on, and then that director would need to ultimately, that affidavit is filed as evidence, but then that witness would then need to appear at the hearing at the end. So really it's so that the parties have an idea of what the other side's evidence is going to be. It's not really like in the TV shows and movies where on the day of the hearing, people are flying through the door with things that no one's heard of before. It's actually much more organised in real life. The evidence stage is long and complex. It can involve affidavits from individuals, but it can also include expert evidence if your dispute is about a matter that requires some expert evidence. That might be forensic accounting evidence, or if it's a construction matter, it might be from an expert to talk about the type of work that was done. Either way, it's very expensive and time consuming. And when we're telling clients how much court proceedings are going to cost, usually the biggest part of that cost is preparing the evidence.
Point 4 on the list, attending mediation. This is something we'll touch on again further in this presentation, but usually mediation is a mandatory step that the court orders, which involves the parties having a structured negotiation with an independent mediator trying to guide the parties to some kind of a settlement. And this often does lead to a settlement, but it's very much reliant on the parties, mutually agreeing to compromise. But usually you'll see this as a mandatory step along the way in court proceedings.
And then the hearing itself, it can be anything from a half day to multiple days or even weeks for very complex hearings. Most of the commercial disputes that we deal with, the hearings might be 1 to 3 days. And that's so that all of the evidence can be presented and the witnesses cross-examined and the barristers for each side can make their submissions and their closing arguments, and the court can ask any questions. It can often get bogged down in technicalities, which again can be surprising to people who haven't been to court before. And will nearly always involve the solicitor who you first instruct and then a barrister, and we'll talk more about this later, doing the appearances and the arguments and presenting the evidence and doing the cross-examining. And at the end of that, the judge or the magistrate or the registrar will usually reserve their judgment. In some cases, they might deliver it on the spot, so you find out who has won at the end of the hearing itself. But sometimes you might need to wait weeks or months for them to deliver a written judgment, and that's how you find out what the answer is to it all.
And even though that sounds perhaps like it's the final step, it's not. There's often more steps after that. For example, parties may appeal the judgment to a higher court. There may be further arguments about legal costs that need to be resolved at the end. And in many cases, if you receive a judgment in your favour, this is something we'll talk about a bit later on, you may need to go through further legal proceedings to actually enforce the judgment. So it can be a very, processes within processes is something to emphasise. It's not necessarily in your control that it will come to an end.
So we mentioned settlement and mediation, and if you're involved in a legal dispute, you might not expect this to take up such a large part of the energy and the time of dealing with that dispute. Often our clients think it's just a matter of rushing off to court and they'll have a judge make a decision. But in reality, settlement is a very, very big part of any legal proceedings. The main reason is that going to court is very expensive. We'll deal with costs a little bit more later on as well. But for that reason, because it is so expensive to carry on with a whole legal proceeding, it's really important to consider commercial settlements at every point. And they can be informal offers that might be made between solicitors before parties go to court or at any time before the actual hearing date. Very often, though, they're in the form of a mediation. Again, mediation can be any time. It might be before the parties go to court, but if it hasn't been, then it will usually form part of the court process. Many courts will actually require parties to attend mediation and confirm they've attended mediation before they'll carry on. One reason is that mediations have a really high success rate, because when you actually get everybody in the same room, focused on the issues in dispute, having a look at what time and stress and cost it's going to take to go through a court proceeding, everyone agrees it's probably better to compromise on things in some way, maybe accept a little less than you think you're owed or otherwise, and come to a commercial agreement.
And the courts typically encourage settlement as well. You know, the courts want to see efficient, justice. They have limited resources, so they like it when parties don't, use up all of their time. One of the ways that the system encourages settlement is you can potentially have a better outcome in terms of legal cost implications if you're putting on offers of compromise along the way which are considered as reasonable. And on the flip side, if you're not putting on offers of compromise that are reasonable, and you eventually get a determination against you, there may be sort of a negative impact because you may have to pay a larger portion of the other side's legal costs. So there's all sorts of mechanisms built into the court process to encourage parties to settle along the way.
And again, mediation can be more formal or less formal. Sometimes courts will let parties choose what type of mediation they want. But the common theme is that it's run by an independent and neutral mediator, usually an accredited and an expert mediator, often somebody who's also a barrister or a solicitor, so is very familiar with the process, and assists the parties in coming to a mutual agreement. The mediator doesn't make any determination or decision about who's right or wrong. They might consider the issues in the discussions that go on during the mediation, but ultimately they guide the parties to a commercial outcome that will avoid going to court and help them all walk away and get on with their business.
And the range of available outcomes at a mediation are inherently more flexible as well. You can come up with a sort of a deal that perhaps involves a bit of give, a bit of take, even some, creative new suggestions built into it, as opposed to a court determination, which is usually going to be quite zero-sum, with one party successful, one party unsuccessful, and the unsuccessful party having to pay usually a significant portion of the successful party's legal costs. So because of that sort of high stakes, zero-sum ultimate outcome of court proceedings, certainly in the SME context, where legal costs may be quite, impactful, mediation, we sound like a broken record, but mediation very often, a mediated outcome may be the best of a range of sort of bad outcomes.
And just briefly, alongside mediation or any other formal settlement processes, parties will usually be encouraged by their solicitors to make offers of settlement in a form that the court can recognise. Again, at the end, when you're talking about costs, we'll deal with costs in a moment in a little bit more detail, but they're either a formal offer of compromise or a call to bank letter, and it's where an offer of settlement is set out, and it follows certain regulations in each of those variations. It is made without prejudice, which means that it can't be used as evidence against you in the hearing if it goes to hearing, but can be used in terms of cost orders that the court might make at the end of a hearing. And it's really just to show that the parties have acted in good faith and tried to make genuine attempts at settlement.
A point we'll touch on quickly is using a barrister. We're solicitors. Solicitors are usually who you'll deal with when you get in contact with a law firm. Barristers are also lawyers, but specialised in court processes, evidence, and advocacy. You don't have to engage a barrister, but it typically makes sense with any case that's sizable. It's worth bringing someone in the team who's got the specific legal substance expertise and also the advocacy experience. The reason they're separate to solicitors is just the nature of the industry, but we just think of it as it's another team member you can draft in, essentially. Typically, you'll have a team working for you, a few solicitors, some more senior people, some junior lawyers, divvying up the work as appropriate. and then you bring in a barrister for the most sort of crunchy, contentious part of the actual court proceedings.
Clients often ask us why we can't do the appearances in court and why they need a barrister. But I think in all cases, when they actually see what a barrister does in court, when they're on their feet arguing across case law, they realise that they're quite different levels of expertise within the same profession, and it's worth having one.
Another point we mentioned earlier was that there's potentially extra steps, or usually extra steps, involved in enforcing a judgment. Say you get to the end of a court proceeding, you receive a judgment in your favour. It says that party X owes you Y amount of dollars. They may just pay. You know, there's incentives built in that they may want to get the judgment off their credit report. They may not want interest to accrue, so they may just pay. But if they don't, you may need to use mechanisms through the court system to enforce the judgment. There's quite a range of options. For example, you can send the sheriff's office to attempt to seize assets at their premises, or you could arrange for their bank account to be garnished via their bank, or you could begin what's known as an insolvency process, which would be to bankrupt an individual or to have a company wound up in insolvency. Which one of these options you choose will be very context dependent. And there's often, questions of strategy, questions of cost benefit, of, how far do you want to take a legal proceeding to try and enforce the judgment.
There's also an issue if your court matter and your court judgment deals with orders for specific performance. It's not always straightforward in terms of whatever those orders might be, ensuring that the other party carries that out. If the other party ignores the order, which is something that we unfortunately do see a lot of the time, there are steps the court can take to enforce the additional sanctions. Sometimes they can be criminal sanctions. They might involve the sheriff needing to take action. The difficulty is that once you've gone through all of the cost and expense and the stress of a court hearing, unfortunately, it doesn't mean that you get your remedy handed to you on a silver platter at the end. There are often some other steps that you've got to follow through.
And, we mentioned earlier service. Things like service, which can be a headache, will continue to be a headache at these later enforcement stages. For example, each of the, a writ for levy of property, a garnishee order, you may need to serve these documents personally, which, each of these things adds a little step to the process, which draws out time and it can increase costs. So these are all things lawyers will be thinking about at the beginning of a court case of how might this actually look when it plays out from beginning to end.
And we've mentioned quite a few times the costs of going to court. I can guarantee you that if you go and talk to a lawyer about wanting to sue somebody or go to court, or even if you are served with some court documents yourself, one of the first things your lawyer will talk about will be costs. We spend a lot of time talking to our clients about it. The problem is that as we've set out, that the time it takes to go through court and the work involved requires a lot of work from lawyers and barristers, and there isn't really a shortcut to do that. And it means that the total cost of court proceedings, whether you've got a small claim or a large claim, can be quite substantial. And it does mean that for some smaller claims, it's not commercial to consider going to court, and that's when lawyers will then talk about needing to consider commercial settlements.
Yeah, and it's really difficult to talk about it in the abstract because every case has got its own facts and nuances, but as a really general rule of thumb, if a claim is contested and the dollar value is, say, below 50,000, my instinct tells me that it might be really difficult to get that through the court system in a way that's commercially viable. And what I mean by that is the legal fees, which would include solicitor fees, barrister fees, potentially witness fees, court fees, and so on, may add up to the same amount, if not more, than the actual sum that's in dispute. Once you're getting to about the 100K zone, there's probably more breathing room. There's potentially a slightly more favourable cost benefit of going forward. But ultimately, in the SME context, the reality is, with the system as it is today, is legal fees just, the cost of going to courts can be disproportionately high, which is just a bit of an unfortunate truth. And it's a risk as well, because it's not a process you control. Once litigation is commenced, you're involved, there's at least one other party, there's the court. It's almost like a three-way tug of war how this process plays out. There's no shortcuts. The only way out is either a determination or settlement. Settlement requires the other party meeting you halfway in some way, shape or form. And yeah, it can just escalate quickly in terms of cost, and that's something we sound like broken records, but it's just a huge factor you need to consider from the beginning.
And just briefly, in terms of costs orders, people often have a slightly misguided understanding of how cost orders work, being that they think that if they win in court, the other side will have to pay their legal costs. And that's broadly the rule. So usually the court will make an order that the unsuccessful party has to pay the other side's costs, but it's more complex than that. There are different types of court orders, and in any event, you'll never get back more than 60, maybe 85% of your costs, and it's more likely at the lower end of that scale.
So that's it for the presentation itself. We'll have questions to come, but before that, please do download our Guide to Resolving Business Disputes, which covers a lot of what we've talked about and contains additional information. Good to know for any business, even if you've never been in a legal dispute, to understand the mechanisms of how these things work. We've also got another webinar coming up on the 9th of June, looking in detail at construction disputes, specifically with two of our colleagues. And now time for questions, which a few have come through already. The first one which jumps out to me is it worth it to pursue a default tenant in a commercial lease? This jumps out to me because I think it's very instructive of what we've just been talking about in terms of the distinction between like your legal position in a dispute and your commercial sort of considerations in a dispute. Pursuing a default tenant is likely to be quite a clear-cut legal claim. If they've signed up to a commercial lease, they've got obligations to pay you rent, they've defaulted on those obligations, you're probably legally entitled to, at a minimum, claim the money. You potentially also take steps like begin an eviction process. As to whether or not you should do that, you would want to take into account the sort of commerciality of the situation. If the tenant simply has no money, you might go through a court process, get a judgment. Your only enforcement option is to bankrupt them, which would cost you more money, which you then wouldn't recover from. On the other hand, there may be elements such as the commercial lease would be signed by both the company and guaranteed by an individual, such as the director, in which case you might have an option to go after the individual directly, which would increase your chances of some kind of recoverability, or at least give you more leverage in pressing for some kind of a settlement. It's very step by step. You may, even if someone's being recalcitrant and ignoring letters of demand, commencing proceedings might be sufficient to get them to come to the table and then agree to some kind of payment plan, or reduce settlement because it might be worth it for you to take a haircut in order to get it resolved quickly. These are all considerations from a commercial point of view. So even when it's legally clear cut, it's very much a balancing act between commercial and legal.
All right, I can take the next question. Simon, there's one here about service. So somebody says they have a magistrate's court date in 2 weeks, but have not been correctly served documents, and they were told by the court that they don't need to attend if not correctly served. Is this correct? As a background, it's to do with a business sale. I'm assuming that this person is an individual and would therefore need to be properly served by a process server or in some way having the court papers delivered to them. It doesn't count if somebody emails them to you. They need to be handed to you personally. So it sounds like that might be what's happened as to how this person is aware of the court date, but they haven't been properly served. My advice in that case would be, if at all possible, to get a lawyer to have a look at that document and just find out the context of exactly what has happened, because yes, that's correct. If you haven't been served properly, then you don't need to do anything. On the other hand, if there's some misunderstanding about exactly how you've been given the documents and whether or not that might be service, you certainly wouldn't want to not turn up if there was some position, if you were in fact served, because more likely than not, the court would allow some extra time, but you might have a default judge. The court might make a default judgment against you if you don't respond in time. So a bit more information to know there, but I would be very wary of just not turning up without getting a solicitor or somebody who knows, just to have a little bit more a look at it for you.
And the courts can be imperfect at times, especially when they're managing a large volume of claims. And sometimes, even if something hasn't been served properly, it might get through to the next stage. And if that's the case, you often can take steps to wind that back. But it's always more difficult and more resource intensive to do that, to unwind something, than to get ahead of it. So yeah, I'd echo Jodie's view that whilst it's sort of in principle, you ought not attend if you haven't been served. It's still worth investigating, just to try and close off any risk of something happening without you being aware. Sorry, Jodie. I was just going to say
Simon.
The next question that jumps out to me is for smaller claims, e.g. less than 50K, is the Civil and Administrative Tribunal or Small Claims Division a cost-effective option? Short answer, yes. To touch on it briefly, there's different courts and tribunals in each state. Typically, you might be in a higher court if it's a larger size money claim. There's two options usually for smaller claims. One being the Small Claims Division of the local court in New South Wales, the other being the Civil and Administrative Tribunal. Sometimes you can pick and choose your jurisdiction. There's different pros and cons. The Civil and Administrative Tribunal is designed to be a bit more user-friendly, and it's also designed in most cases for you not to need a lawyer to work through it. Procedurally, it's slightly less formal. So if you've got a claim such as a consumer claim, which fits within the Civil and Administrative Tribunal's jurisdiction, often our recommendation to clients will be, it's probably not commercial to have us involved beyond giving you some, review and advice. But if you did want to take it further and you wanted to self-represent in the tribunal, that's a cost-effective way to take it forward. And one of the things to keep in mind with the tribunal is, in most cases, parties don't have to pay the legal costs of the other party, even if they're unsuccessful. So there's sort of a slightly lower risk profile for the tribunal. Small Claims Division is there's 20K and below in New South Wales in the local court. There may be some cost implications, but they're usually quite low. Maybe only 10 to 20% of legal fees will get covered. It's less formal than the upper tiers of the local court and the Supreme Court, but it's more formal than the tribunal. As to whether or not it's the appropriate avenue, it will really depend on the context. But I think in summary, in my experience, both of them can be good cost-effective procedures in circumstances where you don't want to engage a lawyer to take it all the way through.
All right, the next question. This is a really good question because it reflects the complexity of going to court. Is win or lose the only results in a court? Can there be other results? absolutely, yes, there can be other results. In some cases, it is win or lose. It might be the case that the court finds that indeed the other party does owe you all of the money that you're claiming. But in many cases, it's not that straightforward. Even in what might seem like a straightforward money claim, once all of the evidence is put on, the court may find that for some reason that amount should be reduced or broken up in some way. Sometimes courts will make orders that nobody gets anything, that each party should walk away and pay their own costs, and they really have some discretion, depending on the evidence put in front of them, to make a decision about what the result should be. And they can be quite complex and multiple orders. They might find that a party was partially responsible for something that went wrong. So they shared some contributory negligence, and in that way, the results are certainly not a simple win or lose. And as a result of that, the costs orders can follow. So if you do get somewhat of a mixed result where perhaps the full claim amount isn't achieved, or the court finds that both parties are partly responsible, they might not make any order as to costs. It might be that, well, you can both just go away and pay your own costs. And that those type of mixed results are not unusual, mainly because most disputes are really complex. They're not simple.
Another one that has just come up is, I would like to know when an alleged offence becomes a criminal case versus a civil case. It's a good question. I mean, what we've been talking about today, commercial dispute, sort of fits into the category of civil. Sometimes, going back to the first slide we looked at, where there's lots of different types of claims one could make, criminal claims is a completely different category governed by different legislation. There are some areas of law which could be civil or could be criminal. For example, fraudulent conduct can be a crime. It can also be a private, you could make a private civil fraud claim against someone. As for when something is one or the other, I suppose it depends on who's making the claim and how they do it. If we're making the claim, we're commercial lawyers, we're not going to commence criminal proceedings. That's a matter for the police, essentially. So it may well be the case that you could report something to the police, and the police would then determine whether or not they're going to take legal action. And separately, you may have some kind of commercial cause of action which you'd like to explore, which you can engage a lawyer to do privately on your behalf. And one of the distinctions there is, if you've got police prosecuting a criminal claim, is you're not going to be incurring legal fees to do that. Whereas if you're engaging a lawyer privately to commence civil proceedings, you typically are going to be incurring legal fees.
Another good question, is arbitration very common in commercial litigation? It's not very common, but it is common in some particular types of litigation. For example, it's more common in construction disputes because there is an arbitration process set up that can work very well to resolve construction disputes. Similarly, it can work very well if one of the parties is based overseas and there's an international element, so it can be a more neutral way of stepping out of a particular country or state's court system. But arbitration is often specified in a particular contract. So a contract will usually contain a dispute resolution clause that tells parties that if a dispute comes up in relation to the contract, how they should resolve it. And some dispute resolution clauses quite specifically say, if the parties can't resolve this by themselves, they must do so by way of arbitration. It might be very particular about which arbitration organisation. If there's not a particular reason to go to arbitration, it's probably not the best bet. There are some pros and cons. It's different from mediation in that there is an arbitrator who makes a decision. It can be quicker and cheaper than court in that it has different processes. It can vary depending on the arbitrator or the organisation that's running the arbitration. as to what level of formality or documents or evidence might be required. But by the same token, in some cases that can be quite detailed, so it can still be very expensive. You still need a lawyer, and the decision is binding. So that is one thing that's helpful, unlike mediation where it's the parties dealing with it out of court.
Alrighty, we've just ticked over to 11:40, so I think that's it for time. Got a few more final housekeeping things to touch on. So LegalVision's a membership law firm. We offer quite a unique service offering whereby you can sign up for a flat monthly fee, have access to a big team, including myself and Jodie, of in-house lawyers who can assist your business with document drafting, legal advice consultations, things like trademarks, and all of this is included, all BAU, business as usual work like this, is included for a flat fee. So you get access to a platform, you can book in, you can speak to a lawyer usually within 2 hours, and we've got 5 business day turnaround for drafting of documents and things like that. So it's a good sort of affordable, certain fee for SMEs. And then separately to that, for anyone who's attended today who wants to have a consultation, whether that's about a legal dispute or a potential dispute, or whether you're just interested in learning about LegalVision's service offering for general membership for commercial legal services, do feel free to book in a consultation. You can leave your contact details in the survey, which will be circulated. We'll get in touch. We'd love to have a chat. And that's it. Thanks so much. Thanks everyone for tuning in. Thanks for your questions. It was good. And no doubt see you next time.
Thanks everyone.